Good afternoon, and thank you for joining us today for this webinar brought to you by Beresford booth. I'm Dimitra Scott. I am the chair of our family law group, which also includes assisted reproduction and adoption. And today I wanted to present a webinar with respect to focusing really on some of the prerequisites and questions that often come up in a private adoption in Washington State. And so now I'm going to turn to my slides. All right. So today we're focusing on private adoptions in Washington State. These are different from any other type of adoption, such as a agency placement through DCYF, which would be considered a public adoption. So private adoptions are oftentimes cases where you are either matched with a birth parent through an agency, a private agency, or directly through your own efforts of self-promotion, trying to find a birth parent. And as I said, this is somewhat different from a adoption where you have been matched with a foster child through the Division of Child and Family Services, DCYF, which was formerly known as DSHS. These children are often brought in by Child Protective Services. They're children who are in need of a temporary placement while a birth parent works on rehabilitating themselves to be capable of parenting. And in those situations, you're taking a temporary placement for a period of time until that birth parent can either rehabilitate themselves or until that child becomes eligible for adoption. That can take sometimes 12 to 18 months before we know the answer to that. And it is really in the hands of DCYF to make those decisions. But again, today our focus is really on private adoption, where you have been matched with a birth parent, either through a private agency or through your own independent efforts. Washington is a direct placement state. That means that you are allowed to take placement of a child directly from a birth parent. It does not have to come through an agency. Agencies often help in making these connections between families looking for adoption placements, either through an agency or through entities that are facilitative. They can help to make those connections. So if that's the route that your family is taking for purposes of an adoption, it's important for you to understand a few things in Washington State that are both prerequisites and often asked questions in a private adoption. So for every private adoption, it's important to know that your first step is to have your pre-placement home study conducted. It is a requirement before a child is placed with you on a temporary basis, or even on a temporary basis, that you have a complete and current home study conducted. It has to be conducted by a qualified independent adoption social worker. And oftentimes these home studies will include an in-person home visit, either a discussion with references or written references from other individuals who can speak to you as a potential adoptive parent. The independent social worker will review your financials, as well as a physician's clearance that's required from your doctor to demonstrate that you are physically capable of parenting a child. There's also an extensive criminal background check that's required for every individual in your household. So this could include yourself and perhaps your partner or spouse, but any other individual who's residing with you, whether that be a sibling or a family member who's staying with you. It could be an adult child over the age of 18 who is still in your home. Every one of those individuals in the household has to go through a criminal background clearance. And it's several parts. It includes an in-state check in the state of Washington, but also in every other state where that person has resided in the last 5 years. So if there's been a lot of moves, there are a number of states where the in-state check is required. It also requires a national background check done through the FBI, which requires fingerprinting for everyone. And lastly, there's also a child abuse network check, or a CAN check, that is required. And this is a nationwide search for any Child Protective Services reports that have been made in reference to that individual's name. All of those are required components of your background check, of your home study. And your independent adoption social worker may have you go through some additional classes and counseling to assist you in preparing for your adoption journey. Once you have a pre-placement home study conducted that has a favorable recommendation for your adoption, you are now eligible to seek a direct private placement. This could mean you are now going through a facilitator or an agency to try to find a birth parent match, or you might be doing this through self-promotion, where you're talking with all of your friends, family, relatives, co-workers, everyone you know. Perhaps you're creating a profile on one of the online platforms that are designated or designed for connecting birth parents. But once you have this home study, you are then eligible to begin advertising yourself as eligible to adopt. Once you have your pre-placement home study conducted, it's important that you know you have to keep it current, because even though your home study has been conducted, that doesn't necessarily mean that you're going to find a match immediately. The general rules to keep that current are that you should have it reviewed every 2 years, or updated every 2 years for an in-state adoption, and every 1 year for an interstate adoption. Your independent social worker can help you with that. And you should keep in contact with them, because you'll want them to assist you down the road in your private placement once you have a child in your home. It's also important to keep in touch with them and seek out updates for your home study to keep it current whenever you have any major life changes, like a change in residence, a change in your marital status, if you have other individuals move into your residence, if there's any major medical changes, things like that. Those would require some form of an update to your home study. And you'll notice where I have the ... next to the interstate adoption. It's important to also know that these are general rules. Some states, in order to comply with the interstate transportation of the child across state lines for adoption purposes, this is called ICPC, in order to comply with those requirements, you might need to have some of your clearances current within a shorter window of time, like 6 months. But you're really not going to know that until you get, until you are in a match, until you have been connected with a birth parent and know where they're located. And we'll talk a bit more about interstate adoption here in just a moment. But the important thing to remember is that you need to have your home study conducted. It must have a favorable recommendation and be current before a placement can be made. So you want to make sure that you mark in your calendar every 2 years for an in-state adoption and every 1 year to keep it current as you're going through your journey to find a child in an adoption setting. One question that oftentimes comes up in Washington State are questions about future communication and contact, the difference between an open adoption and a closed adoption. So I want to start by making sure everyone understands that the actual legal proceedings in Washington State for an adoption are sealed proceedings. They are sealed, they are difficult to access, if not impossible to access. And so from the perspective of what's available from a public records perspective, it's very, very limited and difficult to access. But Washington State is an open adoption state. That means not only are you permitted to have future contact and communication between the birth parents and the adoptive family, you can enter into an agreement which will be signed by a judge as a court order with respect to that future communication. And the type of communication can vary. It could be simply updates such as letters, cards, and pictures on an annual basis shared via email from the adoptive family to the birth parent. It could include something more open along the lines of telephone, Zoom visits, Skype calls between the birth parent and the adoptive family and the child. It could also include in-person visits in an extremely open relationship. And these are all things that need to be discussed and understood between the adoptive family and the birth parent right up front. If the birth parent is looking for a closed relationship and wants no further future communication or contact, but you as the adoptive family were hoping for something more open, then that's something to consider upfront in the match. The agreement and order for contact is not required. It is not required in every case. It is driven by the needs and the desires of the parents and the adoptive family, and what they agree would be appropriate for the child's future. Oftentimes, we will have an agreement that includes things like one-way communication between the adoptive family and the birth parent to ensure that they continue to receive these cards and updates and pictures about the child. And we ask that the birth parent not use those photos for anything other than their own personal purposes. So not posting them online, things like that. But an open adoption and being an open adoption state simply means that you have the opportunity to engage in these discussions and future contact, and that the court can enter an order that is enforceable with respect to that future communication and contact. Not all states have open adoption agreements. And so this is a unique characteristic in the state of Washington. Another question that comes up often, particularly in private adoptions, is whether or not an adoptive family can reimburse expenses for a birth mother. And the answer is yes. Reasonable expenses can be reimbursed, but they must be approved by the court. These expenses could include things like some supplementation for rent, perhaps food, a maternity clothing or replacement clothing, allowance. Counseling is a big one. The statutes allow for the adoptive family to pay the medical expenses of the birth mother and child without a court order, but these expenses outside the medical expense category need to be reasonable, and they need to be approved by the court in advance. And it's an important thing to note that you don't want to, well, you have to be careful in your discussions with respect to birth parents and their expenses, because it is a felony to entice a birth parent to terminate their parental rights through payment of their expenses, through payment of money, right? You simply cannot pay someone to terminate their parental rights. So it's important to have the budget reviewed by an attorney to ensure that it is reasonable, to petition the court for an order that approves the budget in advance. And then once the court has approved the budget, the method of payment is to have the birth parent's expenses paid directly whenever possible. So if we know that some of these funds are being paid to the landlord on a monthly payment basis for rent, those should be paid directly to the landlord. If we can pay directly the utility bill or the cell phone bill, those should be paid directly. If there's questions about how payments should be made to a birth parent, those are questions we're happy to answer for you along the way. But the general rule is that payments should be made directly to the expense. As I mentioned earlier, it's important to also keep in mind that sometimes in a private adoption, you're not going to find a connection with a birth parent necessarily in the state where you reside. So what happens if you have a match made in another state? First, it's really important to reach out to counsel early on to determine which state is the most appropriate forum for this adoption. It might be that the state where the birth parent is giving birth is the more appropriate forum for some portion of the legal proceeding or for the entirety of the legal proceeding. And so by contacting counsel early on, we can make inquiries with counsel in the state where the birth mother resides or where the child is going to be born to make a recommendation to you about where the case should actually be pending. That's number one. Number two, There are different rules in other states with respect to how placements can be made. There are some states that are different from Washington, which remember, Washington allows a direct placement of a child to a birth or to an adoptive family. Some states require an agency to be in the middle. So an agency placement of a child to an adoptive family. So again, that's a good reason to consult counsel when you are connected with a potential birth parent in another state. Also, it's really important to know that there is an administrative overlay on any adoption proceeding that is outside the legal proceedings. And this is related to the Interstate Compact on Placement of Children, or ICPC. In order to move a child across state lines for adoption planning purposes, you have to have approval from the state that is sending the child and the state that is receiving the child. And so there are administrative offices. Some are state-run offices, some are delegated to agencies in other states. But there are ICPC administrators in every state who can review on behalf of the sending and receiving state and give approval for that transfer to take place. It's important to know what the requirements are for the ICPC in both states early on, or as early as we can, because every state has slightly different requirements or expectations with respect to how the package will be provided to them. And that could impact the timing for things like the signing of a consent for adoption. Even though it might be permissible to sign a consent for adoption in the state of Washington before the child is born, perhaps in the state where the child will be born, ICPC expects that consent to be signed after the birth or some period of time after the birth. And so we have to be mindful of not just the legal proceedings in Washington state and the requirements here, but also the expectations in order to receive ICPC approval in both states. Also, when you're working on an independent adoption, especially if you're not using a facilitator or an agency to find your connection, there's a few other things that you need to be aware of that can impact whether or not the connection that you've made with this birth parent will be a good match. Two of these items are related to federal statutes, and so they are applicable nationwide. The first is the Service Members Civil Relief Act. If either of the birth parents, so the birth mother and any possible birth father, are members of the armed services, we need to know that early on, because there are certain notices required and extensions of time required for any of the members of the military in the event they are going to be participating in this adoption plan. So that's one thing to keep in mind early on. Second, we have to know if any of the birth parents believe that they have any Native American or Native Alaskan heritage. And this is related to a federal statute known as ICWA. Washington state also has a similar statute, which is which closely aligns with the federal statute. So it's important for us to know these issues up front. In the event that any of the birth parents have Native American heritage, we have to determine whether or not this federal statute applies to this child. And that often includes an early notice to the tribe that they are affiliated with to ask whether or not they believe this child is an ICWA child. Third, another important consideration in most matches, particularly in the state of Washington, is it's important to gather information about the alleged father or fathers. Is he known and supportive of the adoption plan? Is he known and likely to be unsupportive or simply difficult in the plan for the adoption? Or are we not certain who it could be? All three of those answers give us different pathways to follow to determine whether or not this will be a successful match. So those are three other issues that are not on the slides, but are oftentimes considerations and things to discuss early on in a private adoption. In addition, there are always a number of other questions that come up, particularly once your match has been made. Once you have made a connection with a birth parent, whether through an agency, facilitator, or through your own efforts. Perhaps you're wondering whether or not or how you can obtain prenatal records to confirm the pregnancy. Or we're far enough along in the pregnancy that we need to start making contacts and inquiries to hospitals to determine how they will deal with the delivery and the discharge. These are all questions that come up, and the sooner you contact counsel when you're in a private adoption, when you've made connection with a birth parent, the sooner we can start helping you to answer some of those questions, to try to gather records, medical records for the birth mother and perhaps the fathers, in order to develop a plan for you to move forward now that you've made that connection. So if there are other questions that come up for you, whether now as you're considering how you're going to begin your adoption journey, or because you've already made a connection with a birth parent and you'd like to move forward, under any of those scenarios, please feel free to give us a call. We're happy to do a consultation with you to determine how we can help you move forward in your adoption. If you have any questions, this last slide has our contact information, and we look forward to hearing from you. In addition, next week, I hope you will join us for a presentation by Per Oscarson. He will be discussing the process of recording documents in real estate records. Thank you.